Well, good morning, everyone, and welcome to our virtual town hall this morning. My name is Michael Gault, and on behalf of Lindsay Carrington and myself, we are with Bell Carrington, Price, and Gregg, and we are eminent domain attorneys who represent landowners in eminent domain matters in various jurisdictions throughout the Southeast. But if you're here with us today, then you're here to talk about phase two of the Spout Springs Road widening project. I've had to practice how to say Spout Springs a number of times. It's quite a tongue twister, but we'd like to welcome you here to this town hall this morning. And let me begin by just giving you a brief overview of what we're going to touch on here today. Obviously, in a public forum like this, our ability to give legal advice is limited. Our ability to give advice, sort of one-on-one about specific parcels or specific impacts is limited. But instead, we'd like to take some time today to touch on the eminent domain process in general, what that looks like, how the process normally flows, what eminent domain means, what you can expect throughout this process, and then provide you with some answers to some frequently asked questions about projects like this. Without any more delay, let's jump right into it. Again, if you're here with us today, then you know that we're talking about phase two of Spout Springs Road widening. This is a major, in the before, it was a major two-lane arterial road between Flowery Branch down to 85. If you live or work in this area, you know that congestion is a major problem. The DOT, and in particular the Hall County, is offering or making an effort to widen this road for a number of reasons. They say that they want to improve congestion. They want to improve safety statistics and reduce the frequency of crashes along this roadway, and generally to make it more available and more viable for the increased traffic that's in the area and using this particular roadway now. As I mentioned, in most sections, the roadway is currently 2 lanes. But after this project is completed, we're looking at 4 lanes in most sections with a raised concrete median and then some additional pedestrian and bicycle lanes on either side. And so to do that, obviously, to take a roadway from 2 lanes to widen it with a median to 4 lanes, naturally, that's going to impact the property on both sides of the roadway. And in order for the DOT or a county road project to go forward, private property on both sides of the existing roadway will need to be obtained. Now, that could be obtained through a number of ways. The government, in this case, the county, can reach out to you and say, we're going forward with this project and we need to take your property for it. We need to buy your property for it. We're offering to buy that for X amount of dollars. But if that doesn't work, then the government has what we call the theory of eminent domain or the power of eminent domain. And that means that the government has the right, under certain circumstances, to take private property for a public purpose. Take is the optimal word there. There is a mechanism through the law in Georgia where even if you don't agree to sell your property to the government to complete this road project, it can be taken anyway. That is a right that the government has. But it's important for you as a landowner to know that you also have rights. And among the most important of those rights is the right to what we call just compensation. And that means essentially that even though the government has the right and the ability to take property to complete this project, they have to compensate landowners fairly and adequately for what the property is worth, along with any damages to the remainder of that property. And so what does that look like? Well, we know that right-of-way acquisition started in this project back in the fall of last year, and it's going to continue through the remainder of 2023 until acquisition is complete. But at that time, or during this time, you've likely been contacted by or will be contacted soon by a representative from the DOT. Oftentimes, these folks work for third-party right-of-way agencies, and they are agents that will be tasked with negotiating and obtaining as much property for the project as possible. They're going to make you an offer. Oftentimes, you may not agree with that offer, or that offer may not encompass everything that you're entitled to as far as just compensation is concerned. That's sort of where we come in. It's our role at Bell Carrington, and it's our job and our passion to represent landowners in these cases to make sure that we are able to identify the impacts to your property, to value the just compensation that you are owed, and then to negotiate for that payment to you as a landowner. It's very important for you as landowners to realize that you only have one bite at the apple in cases like this. once this project is complete, a couple of years down the road, 3 years down the road, whenever that may be, and you walk outside and you look at the completed product, the completed project, and you realize that the impact to your property is far more significant than you were able to gather through looking at plan sheets or drawings now, and you accepted an amount that was based on some erroneous conclusion. You can't then, in 2 or 3 years, come back and say, hold on, wait a minute, you didn't pay me for this impact. What you accept now, what you agree to accept now, what they offer to pay you now, and ultimately what the case settles for is it. That is your one bite at the apple. And so it's even more important to have a second set of eyes, to have folks that, like us, that know eminent domain, that know the process. We know the terminology. We can help identify those impacts through the plan sheets and through our team of experts that we work with daily on projects like this, to make sure that your property is protected, to make sure that your rights are protected, and ultimately to make sure that you receive the just compensation that you are due at the end of the day. Some of you, that have been contacted already, that can be sometimes an overwhelming experience, certainly a confusing, maybe a scary experience. You're being approached by people who do this all the time, folks who work with eminent domain matters daily, and so they know the terminology, and they'll throw around the words and the offers and the justification for those offers. And just the thought of someone coming to take property from a private landowner can often be, again, overwhelming. But it's important to know that you can have the opportunity to have someone on your side who has an equal, if not greater, amount of experience in these matters, who can help, again, make sure that your rights are protected and that you receive the just compensation that you were owed on a project like this. Impacts can vary wildly. They can be what we call strip takes, which is a small portion along the frontage of a residential parcel, or if you're a commercial landowner, those impacts could be far more significant. They could impact your access. For instance, right now, if the public can make right and left-hand turns into and out of your property, but after this is over, they can only make right turns. That decreases your property value. It devalues your business. And so those are examples of impacts that we like to look for when we're representing landowners, both residential and commercial, on projects like this. I'd like to close just with a couple of notes about the way that the attorney process works with an eminent domain matter, at least here at Bell Carrington. A couple of things that I can guarantee you. Number one is that we invite you to reach out to us for an initial consultation. That consultation is always free of charge. It is always no obligation. We are happy to listen to you, to pull up your project. We are fortunate enough in our practice to have some proprietary software that will allow me in real time during our initial consultation to pull up the impact to your property, to tell you, number one, if you are impacted, and number two, how we believe you may be impacted, and number three, how we may be able to help. We can do that during that first phone call, and please reach out to us. Again, no cost, no obligation. We're happy to sit down on the phone with you to find out what that impact looks like and how we may be able to help you go forward. This is our passion. This is what we do all the time, and so you're certainly not bothering us, and we like to take the time to speak with you. Even if you're not impacted, it's worth us looking into it to find out if you are. That consultation, again, is always free, no cost, no obligation. The second thing that I can tell you about our eminent domain practice at Bell Carrington is that we operate on what is known as a contingency fee basis. And basically that means that as a landowner, you'll never have to come out of pocket or pay any retainer fee up front or at any point throughout the case. Instead, our fee becomes a percentage of the just compensation that we're able to recover for you at the end of the day, be that through a negotiation and a settlement in the case, or ultimately after a jury trial, which is possible at the end of the day. We realize that for many landowners, particularly residential landowners, it's not feasible to come out of pocket and pay, exorbitant attorney's fees, to pay a retainer, to have somebody charge you hourly or bill you hourly, and to be worried about that through the process. And so that's not what we do. Our fee is contingent on the recovery. And if we're not successful in increasing your amount of just compensation, then you're not responsible for paying any attorney's fees in these cases. So it's truly, no cost, no obligation. Let's get together and talk about how we may be able to help you. And then when we're in a one-on-one situation, I can give you a little bit more information about how that contingency for fee might work in your particular parcel on your particular impact. It's difficult to do that again in this public forum, but as we are on the phone during those initial consultations, we can dive deeper into what that fee structure looks like, and I'm happy to answer any questions you may have about it at that point. So we're at just about 10 and a half minutes now, and I know that your time is valuable. Just generally to recap, the project is going forward. Acquisition on phase one and construction on phase one is ongoing and potentially complete in some areas. And then we're talking about phase two, and the acquisition for phase two is ongoing. Acquisition is the phase where the government will obtain or attempt to obtain all of the private property that they need to complete this project. And you, as a landowner, will be on the other side of that. You're going to be contacted, or you've already been contacted. It's important to know that you don't have to accept the initial offer that's made to you. Oftentimes, damages are missed, valuations are missed, and the offer is low and doesn't really encompass what you're owed for just compensation. And so we invite you to reach out to us. You'll see our contact information either in the description of the video or in the chat box. Feel free to email or call. Someone on our team will be standing by to be able to pull up your impact quickly during that initial consultation, and we will really dive down into the weeds of how we may be able to help you going forward. Again, Michael Gault and Lindsay Carrington with Bell Carrington, Price and Gregg, eminent domain attorneys for landowners. And we appreciate you joining us here today, and I look forward to hearing from some of you here soon. Thank you.